So, good morning and good evening or good afternoon, everyone. Thank you for joining the US Asia Law Institute this morning, and welcome to our speaker, Trang Phạm Ngọc Minh, Pham Ngoc Minh Trang, or just Min, to us who know her well. She's a recent Fulbright Scholar in residence at the US Asia Law Institute, and also a lecturer at Vietnam's National University in Ho Chi Minh City. So my name is Peter Dutton. I'm a senior fellow at the US Asia Law Institute and also an adjunct professor of law at NYU. I'm also a professor of strategic studies at the US Naval War College. I'll be moderating today's event. Before we get started, I've got a few housekeeping notes to share with you. This event, as you may have seen, is being recorded. We will post the video at USALI.org in a few weeks' time. It takes a little bit of time for us to process the video before we can post it. Additionally, one thing I would like to talk about today is questions. You'll have the opportunity to direct questions to the speaker, but I'll need to ask you to type them and then to post them, and I in turn will be asking them of the speaker. In order to help me, I hope you'll keep your questions very brief. One sentence, if at all possible. And the reason for that is that it's hard for me to follow two conversations at once, and your question's more likely to be asked if it's short. Additionally, I would like to share with you about USALI's next Zoom talk. The final talk for this semester will be on Wednesday, June 3rd, starting at 10 a.m. Eastern Time. That's American East Coast time. The event is titled Journalists in the Crossfire, and our guests will be two journalists who were recently expelled from China, Paul Moser of the New York Times and Josh Chin of the Wall Street Journal. I'm really looking forward to this event. The two will discuss their expulsion as well as the implications of ongoing tensions between the United States and China. The event is going to be moderated by USALI's or USALI's Executive Director, Catherine Wilhelm. You can learn more about this event and also to register to get the Zoom link at usali.org. So Min this morning has titled her talk, Vietnam's Approach to the South China Sea Disputes. After a formal presentation, 20 minutes or so, she and I will have a conversation and we'll talk with her a little bit. And then Professor Jerry Cohen will chime in to give his views and to ask some questions of his own. After that, we will open it up to you all for questions from the audience. So again, if you'd like to submit a question, please click the little button at the bottom of your Zoom screen that says Q&A and type in your preferably brief question. So welcome, Min. Thank you so much for joining us. I know it's late for you. I can see the dark window in the background, and you can see the bright sunlight in mine. So we really appreciate your staying up late to talk with us. How are you this evening?
Really well. A little bit hot, but I'm good. And thank you for introducing me. Can I jump in with my presentation now?
Please do. We're eager to hear what you have to say.
Okay, the topic of my presentation today is about the new approach of Vietnam to the South China Sea dispute. And in this presentation, I will briefly talk first the legal conflict in this sea area. What do the claimants in this area argue about? And then I will talk about the evolution of Vietnamese position toward the dispute, including the claim and also the legal option for Vietnam. Good. So let's start first with the map over here. On the left side of the screen, you will see the map of South China Sea. It has the name South China Sea because it's located at the south of China. That's it. The South China Sea is part of Pacific Ocean, and it's bigger than the Mediterranean Sea in Europe. And you can see over here, the area where I marked a purple stripe is the high sea, where every country in the world can access into the area and enjoy freedom of the sea, including freedom of navigation. And around this area, we have China, Vietnam, Malaysia, Brunei, and the Philippines and Taiwan over here. They are the claimants of the South China Sea. And in this area, we have two important archipelagos. In the north, we have the Paracel archipelagos, and in the south, we have the Spratly archipelagos. And this is where our dispute begins. So in terms of Paracel archipelagos, we have Vietnam and China both claim sovereignty over the maritime feature in Paracel. Things are a lot more complicated in Spratly archipelago in the south, because not only Vietnam, but also not only Vietnam and China, but also Malaysia, Brunei, and the Philippines also claim sovereignty over some of the whole maritime feature in Spratly. And it leads to the second category of dispute. It's the dispute related to the interpretation and application of the Law of the Sea Convention, aka UNCLOS 1982. And according to UNCLOS, coastal states can claim their maritime zone toward the sea to 200 nautical miles of EEZ or further than that for the continental shelf. And because geographically speaking, the South China Sea is not really wide. So for example, you can see over here, when Vietnam claimed the continental shelf toward the South China Sea, it will have overlapping continental shelf with Malaysia. You can see the orange part over here is the overlapping continental shelf of Vietnam and Malaysia. Also, Malaysia, Brunei, and the Philippines, they are next to each other. And when they claim EEZ, exclusive economic zone, or continental shelf, is also overlapping with each other. And in order to make life more difficult, the Law of the Sea Convention also say that if one offshore maritime feature is recognized as an island, it can generate the EEZ and continental shelf by itself. So imagine that if one maritime feature in Spratly archipelago is island, so we can have the dispute of sovereignty over this island and the dispute concerning overlapping maritime zone generated from this maritime feature. And then we have China, who single-handedly claim 80% of the South China Sea within the infamous 9-dash line, overlapping everything with everyone in the South China Sea. And China is also the country who behave the most aggressive in the South China Sea. Why? Your Honor, I would like to present Exhibit A. 2014, China sent the oil rig in its course with China Coast Guard into the EEZ of Vietnam, and causing a huge tension between Vietnam and China, also disturbing peace and security and good order of the whole region. And then in 2019, history repeated it again when China sent its survey ship to the EEZ and continental shelf of Vietnam, escort with, of course, Chinese Coast Guard to conduct survey in the EEZ and continental shelf of Vietnam. Also increase the diplomatic tension between Vietnam and China. And in 2020, this year, the target of China is Malaysia. So when Malaysia conducting its exploring exploring oil in this area where I pointed here, China sent its survey ship with the Coast Guard to disturbing that activity, and Vietnam is causing a standoff between three countries: Vietnam, Malaysia, and China. And the Philippines this year also locked 2 diplomatic protests against China. First, because they say that China naval ship pointing a gun directly to their anti-submarine corvette of the Philippines. And secondly, because the China established 2 new districts in Spratly archipelagos. Vietnam and Malaysia also protest that action of China. according to Vietnam, Malaysia, and the Philippines, the action of China not only violated sovereignty of them, but also violated seriously international law. So I have just painted not really positive pictures of South China Sea dispute. But the situation here should not have been that way, because in 2016, we have the judgment of a legal and lawful international tribunal concerning the dispute in South China Sea. It is called South China Sea case. In 2013, the Philippines initiated a case against China before the arbitral tribunal established under Annex 7 of the Law of the Sea Convention. And 3 years later in 2016, the tribunal released its ruling. Among other things, I find 3 most important points. That first, the tribunal stipulated that the 9-dash line has no legal basis or whatsoever. So the historic claim of China within the 9-dash line is also illegal. No features in Spratly archipelagos are island, so they cannot generate any maritime zone around themselves. And finally, member states of the Law of the Sea Convention, including the Philippines and China and Vietnam and Malaysia, must claim their EEZ and continental shelf according to UNCLOS. So you cannot claim your maritime zone in the South China Sea based on a very controversial notion, a concept like historic rights or historic water. So in the map here, in the 2 map over here, I will show you that the aftermath before and after the 2016 ruling. On the left side, we have the map before the 2016 award. We have that within the 9-dash line, this is the disputed area. But after the 2016 award, the disputed area in the South China Sea reduced significantly, because the maritime feature, the blue circle you see over here on the second map on the right side, they are not islands, so they cannot generate any maritime zone that overlapping with Vietnam, Brunei, Malaysia, or the Philippines. And one more legal consequence is that China now doesn't have any maritime zone overlapping in the south of Vietnam, of the south of South China Sea. The only disputed area right now, significant right now, is the area around Paracel Island, because we don't know whether it is an island or not. So this is an interesting development for Vietnam to consider about when they bring the case before an international court. So and now I will talk about the.
Before you move on from that slide, Min, can you explain, does Vietnam have a position on whether the parasols have any islands, or are they just rocks?
I will talk, be patient. I will talk about.
Okay, I will be patient.
Okay, I have a whole slide for that. Okay, let's talk about the position of Vietnam toward the South China Sea dispute. So I have to say that Vietnam used to have a deep distrust in international law, maybe partly because our bitter history. We suffered from the use of force of 3 members of Security Council, which were established to maintain peace and security and promote international law. And at sea, China twice used force to take over our occupied maritime feature in the Paracel in 1974 and 1988. So we used to view international law as a tool for advancing diplomatic policy or foreign policy, and we insisted on negotiation as a tool to settle the dispute. But that position changed significantly, and it manifests in the no verbal of Vietnam to the UN in March 30th, 2020. So I will point out 4 important points of the non-verbal. First, it reads, the 1984 United Nations Convention on the Law of the Sea provides the sole legal basis for and defines in a comprehensive and exhaustive manner in the scope of their respective maritime entitlement in the South China Sea. You see, this is the problem of lawyers when they always use big words and complicated structure to confuse people. So I will translate it into normal people language. So according to Vietnam, in this non-verbal, the law of the sea convention is the only legal basis for any claim, any maritime zone claim in the South China Sea. So therefore, Vietnam denied any claim based on historic rights or historic water in the South China Sea. Second, according to Vietnam, the only legal straight baseline system around offshore archipelagos belong to archipelagic state. So the only country who can be entitled to draw a system of straight baselines around themselves is the Philippines, because the Philippines is legally archipelagic state. And if you are a coastal state, you cannot draw a system of straight baseline around your offshore archipelagos. So over here, look at on the map over here. This is the straight baseline system that China draw around Paracel. This is so wrong on many levels, because first, China is not an archipelagic state. And second, if you want to draw the system of straight baseline, it had to be adhered to the ratio between land and water. 9 portions of land and 9 portions of water to 1 portion of land. But in the Paracel, we have approximately 10 square kilometers of land only, and water we have 17,000 square kilometers. So so Vietnam protests this kind of rowing around Paracel archipelagos. And the last 2 points is concerning the question of Peter before. So Vietnam say that the maritime feature in Paracel and in Spratly Island shall be determined according with Article 100 and 121.3 of UNCLOS. And in this article, we have that this is about rock cannot sustain human habitation or has economic life of their own. So according to Vietnam, no maritime feature in Spratly and in Paracel Island that can generate anything around them. And also the low tide elevation or submerged feature, according to the position of Vietnam, when it's situated in the continental shelf of any country, is automatically belong to that country. No occupation of anyone can alter that status. And how about the legal option for Vietnam? So I say, let's go back to this a little bit. I say this is the new approach to the South China Sea dispute of Vietnam, because this is the first time ever Vietnam has clarified in detail the legal basis and also the legal position of Vietnam towards the dispute in South China Sea. And we can see that according to Article 283, any disputed party, before using international court, they have the obligation to exchange view. And in that exchange view obligation, you have to state clearly your legal basis and legal position. And diplomatic exchanging like the non-verbal to the UN can be considered as evidence before an international court. So this can be considered as Vietnam already fulfilled the obligation of Article 283. Therefore, this is an indicator saying that Vietnam is now leaning on the litigation in South China Sea dispute. And it will be amazing if we have the case between Vietnam and China before the tribunal established by under NS7 of UNCLOS, the same as the Philippines did it in 2013. And the dispute will concern the legal status of maritime feature in the Paracel. It will be a very interesting case, and it will help to reduce a lot of scope of dispute in the South China Sea. Or Vietnam and Malaysia can initiate a case before the ICJ or the International Tribunal of the Sea or NS7 arbitration to delimit their overlapping zone in the South China Sea. And finally, international courts can have another function to give legal advice. So Vietnam, via ASEAN, the international organization of the Southeast Asian nation, can ask the tribunal of the law of the sea some legal question concerning the rights and obligation of a country building artificial island in a disputed area. And the rights of international community when some country by building artificial island damage the environment of the area or the high sea. That will be an interesting case to see also. And at the same time, with the litigation, Vietnam have other diplomatic options. First of all, Vietnam, Malaysia, and the Philippines and China can negotiate a joint fishing route at Scarborough Shoal, because according to the award in 2016, the area around Scarborough Shoal is a traditional fishing route of the fishermen from the area. And the second diplomatic option is they will keep negotiate the code of conduct, although this process is already older than me, and they still don't have a draft of the code of conduct yet. So I'm really skeptical at this option, but some diplomats in ASEAN, they really look forward to, so I will put it here. So that's it, the end of my presentation. I keep it short, and now this is for question.
You've done a wonderful job, Min, of laying out both the basic provisions of the United Nations Convention on the Law of the Sea and how they apply in the South China Sea, but also a really nice job of kind of helping clarify Vietnam's newer perspective on these issues. I guess so before I get into my comments and questions, we have a really good question from Professor Alvarez, who's interested in understanding whether Vietnam's interest in possibly pursuing some sort of arbitration or litigation regarding the South China Sea issues also reflects a broader interest in Vietnam in terms of accepting international adjudication and international arbitration. He mentions, for instance, Vietnam's acceptance of the EU's idea of a multilateral investment court. So as an example of a broader change in policy there. And I'm wondering the same thing myself. That's an interesting shift. Can you tell us more about the shift?
Vietnam accept this is the evidence of Vietnam already accept the award, the 2016 award between the Philippines and China. Vietnam did not clearly explicitly say that it accepts, but those 4 points in the no verbal of Vietnam, in the no verbal of Vietnam sent it to the UN, those 4 points is in line with the judgment of the court of in 2016. And the ownership that I have told you, that I have a good feeling that we are looking for, we are seriously consider using litigation as an option for dispute settlement. Because 2 days ago, the Professor Thao, who is a member of the ILC of UN, saying that Vietnam will consider using judicial body as the last resort. But I think this is the time, this is the last resort. You can see the increasing of aggressive action of China in the South China Sea. So what else do we have? The code of conduct has already too long. It's older than me, and then they don't even provide any draft of the code of conduct. Let's compare with UNCLOS. UNCLOS is a really serious convention, but it and more than 100 state parties participate in the negotiation process, and it takes them just 9 years. And then the code of conduct take 11 countries more than 25 years, and not even the first draft. So the negotiation, I think, is already exhausted. So the last resource is litigation, and this is the time.
Thank you. Thanks for that, Min. So a couple of things. One of the things that I think gets overlooked in terms of understanding Vietnam's willingness to use at least international institutions that have an adjudicatory aspect to them is Vietnam's early use and frequent use of the Commission on the Limits of the Continental Shelf, right? So the Commission is not empowered to give a adjudication of the delimitation of the continental shelf. But if you could go back to that slide, Min, where you show the South China Sea, including back one more, there you are. So, so the orange, there's a triangle on top and then a longer bit on the bottom. Those are areas in which Vietnam has what are called extended continental shelf claims. Now, as you pointed out, Min, that whole area that you put purple lines in is a high seas area. Well, that should also include the orange parts as well. That's high seas as well, where the international community also has rights and interests. But Vietnam has a special interest, which is in the possibility of claiming an extended continental shelf there. There's a process under UNCLOS to do that, and an advisory body called the Commission on the Limits of the Continental Shelf that Vietnam has taken advantage of to make its claim in the South China Sea. Now, in 2009, Vietnam and Malaysia joined together to make a joint submission in that southern part. There you go. That part of overlap of potential extended continental shelves. Now that portion right there is beyond 200 miles from the baselines of either Vietnam or Malaysia, right? So it's outside, it's beyond the exclusive economic zone, but it is potentially continental shelf that can be claimed by Vietnam or Malaysia or both of them and then divided. And that's the issue that was submitted in 2009 to the Commission on the Limits of the Continental Shelf. Frankly, it's the issue that started the ball rolling in the South China Sea, because it was the Vietnam-Malaysia submission was really a direct challenge to China's 9-dash line claim based on historic rights or something else in the South China Sea. So I thought that was important to point out, that first to emphasize that there's an area of high seas in the middle of the South China Sea, quite a large area of high seas, which means that the entire international community, because the high seas belongs to all states, so the entire international community has an interest in the development of the South China Sea and the legal architecture of the South China Sea. Second, I wanted to point out that Vietnam and Malaysia have, in fact, actually used some of the rather interesting options available to them under the convention to begin to use international law and the institutions that supports it to challenge Chinese claims rather directly. Now, why do I say that continental shelf claim challenges China's or started things off in 2009. Here we are 11 years later. A lot of it has happened because of this. Well, first, the only way that you could have a extended continental shelf there is if none of the islands in the Spratlys is a Article 121 island as opposed to an Article 121 rock. Right? So a rock can only generate a 12-mile territorial sea rather than the 200-mile resource zones. So you can see the Spratly Islands. If any one of them could generate a 200-mile resource zone, then that orange piece couldn't exist, because the issues of who owns the Spratly Islands remain in dispute. As we know, Vietnam claims all of them, so does China. The Philippines claims a number, and so does Malaysia. So there's that's the first really important point to remember, that Vietnam early, with Malaysia, made a direct institutional and legal challenge to China's claim. And unfortunately, the Philippines could not join that. The Philippines was invited by Vietnam and Malaysia to join, but could not. Why? Because there's a lingering sovereignty claim over, that's it right there, Sabah, right? The province of Sabah. So the Philippines has a lingering sovereignty claim dating back to pre-colonial period, when that province of Sabah was actually joined with some of the islands in the Celebes Sea there that belong to the Philippines, and was united in what was called the Sultanate of Sabah. And so that Philippines was unable to join because because Malaysia and the Philippines couldn't agree on how to proceed in that area with a joint submission to the Commission on the Limits of the Continental Shelf in 2009. And so what, in part what we saw was that the Philippines had to choose a different institutional avenue, which was the arbitration process. So I thought that was worth pointing out as well. There's something else I wanted to point out, and then I'm going to, I've got lots of questions for you. I'll turn to a couple of them in a minute before I turn it over to Jerry also for his comments and his questions. The thing I wanted to point out is this word archipelago, right? It's an important word because, of course, you use it early in this presentation when you were describing the Spratly Islands and the Paracel Islands as archipelagos. You were describing in the geographic sense that there's a group of islands, and the Chinese refer to it as a sha, or a judao in the South China Sea. There's a third word in China, which is chundao. Chundao is the word for archipelago. And the Chinese have, as you pointed out in relationship to the Paracel Islands, the Chinese have been using this concept of chundao, really offshore archipelago, to describe how they would draw their claims in the South China Sea. So the Chinese would say the Paracel Islands, we get to draw baselines around the Paracel Islands. And even if any one of the features alone could not claim a exclusive economic zone and continental shelf, the Chinese say, as a group, we're able to draw baselines around them. And then as a group, a chundao, an offshore chundao, they are able to claim a full exclusive economic zone. So it's a fundamentally different approach. Now, this approach was invalidated by the South China Sea arbitration. Both the idea of drawing baselines around these island groups, claiming them as offshore archipelagos or chundao, and then drawing drawing resource zones from them was invalidated by the arbitration as well. I thought that was worth pointing out, that there's really two approaches that the Chinese take to their claims in the South China Sea. You might describe the 9-dash line as sort of an outside-in approach, that the Chinese use the 9-dash line to claim what's in it, right? And then the other approach is an inside-out approach, right? Which is this idea of bunching together the islands, drawing baselines around them, and then extending resource zones out from there. Now, we don't know exactly what the Chinese want to do in the Spratly Islands, because they haven't drawn baselines in the Spratly Islands. They've sort of signaled to us that that's their clear intention is to do that and to announce them. And some are suggesting it may be sooner rather than later, especially if the Chinese follow through with their threat to have a air defense identification zone in the South China Sea. We can talk about that later if you like. But in the East China Sea, what the Chinese did before they declared an air defense identification zone was they took some earlier steps. They drew baselines around the Senkaku Islands or Jiaoyu Islands, Jiaoyudao, or Jiaoyutai, if you're Taiwanese, they drew baselines around those islands, announced those baselines, and then they announced their air defense identification zone. Why? Because they announced that the air defense identification zone could only occur outside of national airspace, which extends to the end of the territorial sea. So they claimed a territorial sea around the Senkakus, which was actually a bit of a clever move in that what it did was it prevented them from having an air defense identification zone over the Senkaku Islands, which are, of course, administered by Japan. So it prevented that from being part of the actual dispute itself. But if they follow the same process in the South China Sea, you would expect to see baselines drawn around the Spratly Islands, and then an air defense identification zone might be announced in the South China Sea. So, so first, I'll let you reflect on anything that I've said so far. Do you have any comments you'd like to add to what I'm saying there?
I want to comment on the area that you said this is a high sea and it's overlap with the continental shelf claimed by Vietnam. So we had to distinguish the water column, which is the high sea, and the ocean floor that coastal state can generate a continental shelf over the ocean floor beneath the high sea.
Yeah, that's a very good point. Yes.
So Vietnam don't claim the water column be above this orange area, but we claim the ocean floor because we legally can extend our continental shelf over 200 nautical miles.
Right.
And in 2009, Vietnam unilaterally extend our continental shelf, and also jointly with Malaysia to extend the continental shelf, because it was the deadline for state to extend the continental shelf, and that also may upset China. But I don't think we should interpret it as an action to cause China become more aggressive. And that's my clarification.
Yeah, thank you. Well, I appreciate that. And one of the things that I want to ask, I mean, Ira Belkin has this question, which is a good one, which is, can you talk about how the South China Sea dispute has affected China-Vietnam relations? One thing I should point out is that not only do China and Vietnam have close state-to-state relations, of course you share a border, but beyond that you have long historical connections to each other. Sometimes friendly, sometimes not. You also have rather close party to party, right? Communist Party to Communist Party connections as well. So there are many ways in which China and Vietnam, I mean, in addition to sort of economic relations and commercial relations, et cetera, there are many ways in which China and Vietnam are closely connected to each other. And I'm wondering, what's your overall assessment of how the South China Sea disputes have affected the relationship?
So if you look at the history of Vietnam, we only have problem with China, but we are there. We cannot move our country to another place away from China. We are there. We have to live with China, and we appreciate all the things that China helped us in the history. But we also learned that maybe we have dispute, but the connection in economic and trading and other aspects beside the dispute should be considered as well. And Vietnam still consider China a strategic partner. And we haven't lowered that level of diplomatic relation yet. So so far we have the dispute in the South China Sea with China, but we will keep it at low key as much as possible to not damage our overall relation.
Well, see, this is the question. What has prevented? One of our attendees, Zheng Zhihua, is asking this, and it's a good question, right? Which is, what's preventing Vietnam? What are the obstacles that prevent Vietnam from actually filing legal proceedings? There's so many reasons so far to have done so.
I think because using international courts, if Vietnam use international courts at the moment, it will be the first time, and any first time, it needs a long time to process, to consider, and to prepare. And also we have to consider to take into account is that it may take 3 or more than 3 years for the whole process of the international court to release the judgment, and we had to prepare for that as well. We had to prepare during that time. During that time when the court is working, what we're gonna do if China sanction us, for example. So it takes long time, but I think we are really repairing it.
Yeah, thank you. So let me ask you in relationship to that, what would be the objective, right? So what would you be attempting to achieve? So some have criticized the South China Sea, in my view, wrongly, the South China Sea litigation that the Philippines engaged in as being a waste of effort, right? Because they didn't actually get what they want. My view is that's wrong, but I'm interested to hear your views about what Vietnam would be hoping to achieve through the litigation.
So we have to admit with each other that the South China Sea dispute is a big game, and it will not end with just a litigation or 2 litigation in this area. But let's assume that every country in this area are rational, and their action will be based on cost and benefit analysis. So the litigation, if Vietnam sue China, it will increase the cost of China, the legitimacy of China for any action of China in the South China Sea. If Vietnam sue China concern the legal status of Paracel, you will see this map. I will show you this map. We have this dispute area is still big. It's still compared with Spratly. Spratly is quite open now for more changes to cooperation, but this area in Paracel still disputed. So if Vietnam win the case over the Paracel Island, it will reduce the scope of China of disputed area in here, and also will will cause more cost for China if China will not modify their action according to international law and international cost, because the South China Sea game will link to other game of China, the like One Belt One Road initiation of China. So if you prove yourself that you are a bad actor, bad player in this game, how can you convince other player in the other game that you will play with the rules? And also Vietnam and China will see it again in other many actions. So the shadow of the future will hold China in that aspect if there is another litigation.
Yeah, I think that's a very important point. You can see Vietnam looking at this in terms of the long game and sort of increasing political and diplomatic costs to China for its behavior. So you mentioned Article 283. I think that's important. There are 2 things I want to come back to. This exchange of views requirement. Do you think this exchange of letters and notes that I referred to earlier in the exchange of notes that's been ongoing for more than 10 years through the Commission on the Limits of the Continental Shelf process, right? So immediately after Vietnam and Malaysia filed their South China Sea extended continental shelf claim in 2009, China responded with the very famous letter, right? Which was the letter that they attached the 9-dash line map to, right? So that made it clear. And it was that letter and that map that led to the Philippine arbitration process. So that, and then there was another letter in 2011, and then there's just been an ongoing exchange of views between China and each of the South China Sea claimants in the last 11 years. And I'm wondering if you think that's a sufficient exchange of views, or do the parties actually literally have to sit down and meet face to face to address them? What are your thoughts on that? And then I'll come to my next point on UNCLOS.
Okay, so if we look at the South China Sea case judgment again, and other case of the ICJs or other case of arbitration, we can see that the obligation of exchange view, the court will not consider that they have to be exhausted. The party to the dispute already clearly clarify their view, clarify their claim, and that view adhere to the dispute between them with good faith. This already enough for the obligation of exchange view to fulfill. So my point is that according to the practice of international court, it doesn't necessarily to be exhausted.
So good, thank you. That's right. It doesn't need to be exhaustive. It just needs to be clear. I think is as close as we could, if we want to summarize the tribunal, taking it out of legal language, right, as you said earlier. I have there's something that's always I've been curious about. So of course, for a long time, Vietnam and China have had lots of problems, right? So we know Haiyang Shoyo 981, the drilling rig, right? That was parked by China a couple of years ago off the Paracels, caused a lot of problems. We know also the Chinese have been interfering for a long time, since 2010, 11, 12, in Vietnamese oil exploration. There was an incident with the Vietnamese ship called the Binh Minh, I think, in 2010 or so. And much more recently, there's been a lot of activity at Vanguard Bank, right? I don't know the Vietnamese or Chinese word for Vanguard Bank. It's the area of Vietnamese oil exploration, sort of directly off the Mekong River Delta. And the Chinese have interfered, physically interfered with the Vietnamese activities there. What is surprising to me is that no party, the Vietnamese or the Malaysians, have taken advantage of initiating a case regarding that specific incident, right? It's a behavior at sea that can alone be the subject of litigation or arbitration. And taking advantage of what are called provisional measures, right? So this idea that the court could step in right away as soon as the case is filed, even before, if there's no arbitration tribunal formed, this can go right to the International Tribunal for the Law of the Sea for some sort of immediate legal determination of whether China's interference has any legal basis to it. And then, pending the outcome of the litigation, an answer can be achieved. But in the meantime, there's some legal steps that can be taken. I've always wondered why Vietnam never took advantage of that option.
I wondered the same thing too. And I will write out this question to do more research or more talking. Because at the moment, I don't know. Sorry to say that.
Well, okay, it's something to give more consideration to, because not every case has to solve every problem, right? So Vietnam, if Vietnam wants to take an expansive case that deals with all of the problems of the South China Sea, the way the Philippines did with China, that's definitely a good approach. And it looks like Vietnam is moving in that direction. But there are also smaller cases that can be brought along the way. Right. So if China wants to, or if Vietnam wants to challenge Chinese interference, say with the hydrocarbon exploration vessels, right, or with Vietnamese oil rigs, et cetera, that can be an isolated case alone, and a provisional measure could be brought.
I agree. But my point is that when the Philippines initiated a case against China, it needs a really significant move of China when it's take over Scarborough Shoal of the Philippines, and China didn't let the fishermen of the Philippines go into the Scarborough Shoal area to fish. So this is really a serious action. But let's compare it with the incident in 2014 or 2019. This, as you can say, it is a small incident, and it's happened a few months, and then China will withdraw their oil rig. So maybe Vietnam will sell for the big moment, or for the big case, not just a small case along the way.
Well, we've got a number of different questions, and I do want to begin to turn to them again. So we have a question from Janet Daya Ekawati, who's interested in hearing about what some of the other littoral states in the South China Sea might have a role to play in this larger dynamic. Indonesia, for instance, in particular, she points out, has had problems with China in this area of overlap. Maybe you can point to it between Natuna's exclusive economic zone and the 9-dash line. Can you point your pointer down to where that is? So that's the area there. So that's Natuna, yeah. Now go up to the right to where the orange area is. Yeah. So yes. So you can see where the 9-dash line crosses over the black line. There you go. That area there, the 9-dash line crosses over the black line, which is the Natuna exclusive economic zone. So for a long time, Malaysia took the position that it had no disputes with China in the South China Sea. And this was based on the fact that there was apparently no direct challenge that the Chinese had made to the Natuna exclusive economic zone there, which belongs to Indonesia. And however, over the last few years, the Chinese fishing fleet has very actively and operated in that area and has been protected by the Chinese Coast Guard. So it's quite clear now that Indonesia is also a party in the South China Sea disputes, not to the sovereignty over the islands, certainly, but to this question of who owns the rights to the resources in that water space. So we come to this idea of what some of the other states can be doing in order to play a role in supporting the United Nations Convention on the Law of the Sea in the South China Sea.
So I'm really glad that you asked about Indonesia, because Indonesia just has submitted their no verbal to the UN, clarified their position to the South China Sea dispute. First, it pointed out that Indonesia is not a claimant in the South China Sea, but it will support any action of the party in here according to international law. It denied the 9-dash line. It denied any claim on historic rights and historic water, and it also mentioned that the award, the 2016 award between the Philippines and China concerning the legal status of maritime fisheries in here, and Indonesia say that Indonesia will consider the awards as legal and then legitimate and the legal basis for states to claim in the South China Sea. So you can see that in 2020, three countries in this area. The Philippines already mentioned the 2016 award in their no verbal, and then Vietnam implied the home point of the Nova the 2016 award in its no verbal also. And now we have Indonesia, and though it's not a claimant in the South China Sea, but it's mentioned the award in its no verbal to exchange with the UN. So you can see that in here we have smaller states compared to China, like Vietnam, Malaysia, and the Philippines, and they both modify their claim according to international law and support the awards of the case between the Philippines and China. So it's more pressure for China now.
Yeah, I think this is a very good point. I mean, Indonesia is a very big player, right, in the region. And certainly within ASEAN. So Indonesia's direct support in this regard, I think, is quite significant. I do want to point out that for anyone interested in following, we keep referring to these note verbales, right? So for anyone interested in looking at these or following them, they can be pretty easily located on the website of the Commission on the Limits of the Continental Shelf, right? Which is it's at un.clcs.org, I think, but it's the Commission on the Limits of the Continental Shelf, and you can go ahead. Mm-hmm.
Yeah, you can just type on Google the new no verbal of Indonesia, and it will appear immediately.
Yeah, but what I'm referring to is essentially beginning with the 2009 submission, right, by Malaysia and Vietnam, and then begin to follow that whole line of exchange of diplomatic notes among the countries in the South China Sea. It's very fascinating to watch. And of course, last year, 2019, I want to say it was maybe August, Malaysia submitted a second round of claims to the Commission on the Limits of the Continental Shelf, right? So it stimulated a second round of questions, or of diplomatic correspondence. So there's actually been quite a lot of activity. I'd like to turn for a minute to your question, and we have one or two questions about this as well, to the sort of costs and benefits between taking a diplomatic approach versus taking a approach using the law, or so maybe you can talk about the pros and cons of each, but also I think maybe talk about how they work together in terms of Vietnam's point of view.
Sorry, I don't understand the question.
I'm sorry. So you talked a little bit at the end of your presentation about Vietnam's options, right? Some of which were legal, and based on arbitration or litigation. Keep going. Yeah, there you are. So the category 1 options, right, which are fundamentally about using international institutions to adjudicate questions, right? And then the second category, right, which are fundamentally diplomatic. In other words, some form of negotiation is moving forward. I wonder if you could talk a little bit about Vietnam's assessment of the pros and cons of each. There must certainly be different voices within the Vietnamese system that see the issues differently, and some that are more pro-China than others. This is only natural. So I wonder if you could talk more about not only your own assessment, but what's the sort of politics of the question between approaching 1 and 2?
Thank God that I'm not a diplomat, so I can say whatever I want.
We know that these are only your personal views. We're not asking you to speak on behalf of the government of Vietnam.
Yes. We had to go back to the United Nations Charter. According to Article 2.3 and Article 33 of the United Nations Charter, that any country who has dispute, any kind of dispute, can have the freedom of choose any kinds of peaceful means to settle the dispute, and it can happen at the same time. For example, during the negotiation of the Code of Conduct, Vietnam can at the same time initiate a case against China. For example, and during the process of using the function of giving advisory opinion of its laws, Vietnam can also negotiate at the same time about the joint fishing ground at Scarborough Shoal. So everything is not like you have to go step 1 and step 2. It can happen at the same time, and then you can have all the benefit at the same time. But also you have to consider the difficulty. So for the difficulty of using judicial body, I mean, that's the pressure from China. It may upset China, and China will use their economic tool, or they will continue to send their survey ship or oil rig as a way to tell us that your action is wrong. You should withdraw the case, for example, and this may escalate to a conflict, an armed conflict, and it's really bad situation, and we don't want that to happen. But all the diplomatic option is too long already, and it's also you have to look at the domestic pressure within the country. So why China keep bullying us in the South China Sea, and you do nothing? So the government have to answer the people in the country. That's also so you have to keep balance between the cost and the benefit, and choose the option wisely. And also you can choose everything at the same time. So I hope that that the answer for your question.
Yeah, that's great, actually. And speaking of choosing everything at the same time, there's a sort of a follow-up question in relationship to your 1B option there, right? Which is from Catherine Wilhelm, which is basically, well, couldn't Vietnam and Malaysia, kind of work their issues out separately from China, which I think a lot of people are wondering, what will it take for Vietnam and Malaysia to finalize all of their issues in the South China Sea? I should know the answer to this, but I don't. Has Vietnam and Malaysia delineated their exclusive economic zone boundary to each other?
So this is the outer limits of Vietnam. From the baseline of Vietnam to this area is 200 nautical miles, and then from Malaysia this is 200 nautical miles. So
right, of course, yeah.
Overlapping easy. We only have overlapping continental shelf because we can extend further than 200 nautical miles.
Well, of course, I should have realize that, of course. So what about negotiating the boundary yourselves on the commission, on the continental shelf, and sort of finalizing that issue? I realize that you have a claim before the commission right now, and China is able to prevent that claim from moving forward because it says the region is in dispute. And once another country disputes the issue, the commission has to stop. But you could still work out your boundary yourself on the extended continental shelf, I imagine, as one way to begin to reduce the number of disputes in the region. Is that an approach that Vietnam has considered?
So I think that's why I say that Vietnam and Malaysia can use international court to delimit their continental shelf. Of course, the Malaysia and Vietnam can negotiate negotiation to come up with an agreement that delimits the continental shelf of Vietnam and Malaysia. But with but for me, it will have big benefits for Malaysia and Vietnam if it come out with international cost judgment rather than just two countries have an agreement. And then China will say that China will not recognize our agreement, for example. But for the judgment of international cost, it will have more valid legal basis, because it's also considered as a source of international law.
Well, that's an excellent point. It's interesting to note that I don't think either the International Tribunal for the Law of the Sea or the ICJ has ever considered a case that involves only a delimitation of an extended continental shelf. I think in the Bay of Bengal there's one, and then also there's another one too. Maybe it's
yes.
What's that?
Nicaragua and Colombia.
An extended continental shelf only?
No, they have two cases. The case of their continental shelf within 200 nautical miles, and then another case for the extending continental shelf.
So okay. So this is a sort of a new approach. I think the International Tribunal for the Law of the Sea has signaled it would find it would be comfortable with having jurisdiction over extended continental shelf questions. It's signaled that in a number of cases, beginning as far back as the Barbados versus Trinidad and Tobago case, but it has which was, I think, an ICJ case actually. But then the International Tribunal for the Law of the Sea has dealt with extended continental shelf claims. But I've never seen a case decided yet that involved only extended continental shelf. So that would be a place where Vietnam could be moving the law forward, I think. I have a question for you, because we dealt with the question of historic claims, right? And so China has, their historic claims in the South China Sea have been held to be invalid. But I know that China is not the only one that has maritime claims related to history. I don't, both Cambodia and Vietnam have some sort of historic rights claim in the Gulf of Thailand. And I'm wondering if this is kind of a problem of consistency for Vietnam.
First of all, I have to clarify that the Gulf of Thailand is not part of the South China Sea. And if you see in the novel, we say that it's within the South China Sea area. And also the Gulf of Thailand, the historic water claimed by Cambodia and Vietnam is not disputed by any other country. So it's not difficult to settle the dispute over here. And also Vietnam and Cambodia already has an agreement on this issue, I guess. As far as I know. So
yep,
then
go ahead. I'm sorry, I cut you off.
So I think there is no inconsistent of the position of Vietnam at all.
Yeah. So all right, that's fair. I have another question related to sort of diplomatic costs for China. Deanne Wilson asks this, and I mean it is a very good point, right? Which is that do we think that China has actually paid some diplomatic or political costs as a result of the South China Sea arbitration? I have my own views on that, but I'm interested to hear what you think first.
How about you answer the question first while I'm thinking?
Tossing it to me, are you? Okay, so I think the answer is yes. However, they're sort of indirect costs, and let me put it this way. There's a sense in which now, not just in Southeast Asia, but in the larger world community, that everyone knows what the right answer is in the South China Sea, right? And so that is the right answer in regard to law. In the past, China benefited from a certain ambiguity. For literally decades, China obfuscated about what its claims were, and it took advantage of that ambiguity to make some gains, right? And steady gains over the years in terms of both occupying more islands and of expanding its presence and then expanding its coercive power in the South China Sea. It took advantage of that ambiguity, beginning in 2009 when Malaysia and Vietnam submitted their claim to the Commission on the Limits of the Continental Shelf, but then certainly accelerating after 2016. It's been harder for China to use that space of ambiguity to operate in without diplomatic cost, right? So because the space of ambiguity has narrowed substantially in the South China Sea, so there's legal clarity. So what is the cost, right? So can you point to any direct economic loss? No, but what China has had to do is to be more coercive to get its way. In essence, that is the cost, right? China's had to use more coercive power to achieve its own objectives. This has a resulting friction. For instance, it's now Vietnam's turn. Indonesia is now part of this. Increasingly, Brunei, quiet, little Brunei, is increasingly part of this problem now as well. And so there is a sort of slow but steady momentum among Southeast Asian states to accept some, at least, political and economic costs from China in order to stand up for what international law says belongs to them, right? So the fact that what it has generated in Southeast Asia is a certain determination to continue now for 11 years this process of using international legal systems to push back directly at China. And it has generated some unity, frankly, among the parties that was harder to achieve in the past. And so I think what China's having to do is to accept more friction as the cost of achieving its policies. And that friction has, number one, it's got to be more coercive in doing it. So that's an internal cost, essentially, and an opportunity cost, essentially. And number two, it's got to accept external pressures that are slowly mounting. I mean, let's be honest. China hasn't had to accept high costs, but steady costs. And I think there's a big third cost that gets overlooked. My view is that China's approach to the South China Sea has made American power in the South China Sea more relevant than ever. In other words, if China really wanted to dominate the South China Sea, the best way to do it would be to be nice, essentially to give up its claims, to rely only on the law of the sea convention for making claims in the South China Sea. Leave aside the questions of who owns the islands. China's got basically what it wants out of that process anyway. And let the resource zones be determined by UNCLOS as the coastal states insist is correct. Well, the reason that the United States remains very relevant to the security dynamic of the South China Sea is not simply because we have our own interests there. It's because the coastal states have an interest in having us there too, in order to help provide some measure of balancing power for China. Now, there's a lot of debate about this issue. The Southeast Asians have an interest in not aggravating China too much, and so they don't want to get too close to the United States, et cetera. But the United States always hears from the region, we don't want you to be too close, but we also don't want you to go away, is sort of the larger point, right? And so in the end, the Chinese policies have worked in the American favor. They've cemented American power in the region, American naval power in particular in the region, which seems to be directly contrary to China's, at least their stated objectives, right? But they've made American power more relevant than ever. So I think those are the three ways that you look at the costs. Number one is law and legitimacy. China's always on the wrong side of legitimacy now. Two is the regional response has coalesced and slowly, gained momentum. And I will say, and we'll come back to this point, it has, I think, made it impossible for the region to agree on a code of conduct with China, because it's just not possible. China's trying to gain too much from it. And the third is that the cost that China is paying is it's cemented American power in the region, for yet another generation. So exactly what the Chinese don't want. So I think those are three clear costs, in my view, that the Chinese have to pay. So your views.
And I will build up on your view of that. I think that maybe the law work a little bit slowly, and the benefit of the law maybe at the moment or in the short future is not tangible. But lately it will become more vivid. For example, like 2 days ago, China said that the US is pushing China to the brink of a new Cold War. And I don't think it's true, because look back at the old Cold War that we held between the Soviet Union and the US. They are really two sides of a roof of country. So not only Soviet Union, but also they have allies around themselves. And also Vietnam is also an ally of Soviet Union at that moment. And the US also have a European Union. So that the two group of nations. Now it's not a Cold War. Who is the ally of China, for example? So because the deep distrust of China manifests in the situation in South China Sea. How can China convince other countries to join their ally in this Cold War 2.0? So that's my view.
Yeah, thanks very much, Ben. I really appreciate that. So one of the things that I do want to turn back to before we come to the code of conduct is this point about China's response so far, right? Has been to try to articulate a legal rationale. It's been a discredited rationale, but it's being systematically developed by the Chinese nonetheless for this idea of the offshore archipelagos. But primarily, China's response in the South China Sea has been a power-based response, right? It's been a coercive response rather than a sort of a cooperative response. There's talk about joint development as an aspiration and resource sharing and that sort of thing, but there's been, frankly, almost none of it in the South China Sea. But what we have seen, as you talked about earlier, you talked about the incident where the Philippines were threatened by a Chinese Navy corvette. You didn't mention this, but the Chinese Coast Guard has been rather aggressive with the other Coast Guards in the region. There's much written about this if you want to look about it. And even right now, if you follow things on Twitter, you know that the Chinese have been using Fiery Cross Reef to increase their military activities this spring, right? So April, May, there have been quite a lot of military activities, and some speculation exists on Twitter that there's going to be some sort of major Chinese exercise, right? As sort of a power-based response to this point that you're raising now, right? Which is that the Vietnamese government is considering whether to initiate arbitration, and maybe China's power exercises in the South China Sea will be geared towards Vietnam. Have you followed that side of the issue at all? And I'm wondering if you have, what your thoughts are.
I have no comment on that so far. I had to look more on that.
Okay, that's fair. I'll talk a little bit about it then. Unfortunately, I regret to say that we're not going to have Jerry's thoughtful comments here today. So you'll have to put up with mine. But yeah, this is something that I think we should be aware of, right? That even where Vietnam, Malaysia, Indonesia, and the Philippines, right? The four major Southeast Asian claimants, we can include Brunei too, but we haven't seen much from Brunei. But the four major claimants have all used international law as the basis for their approach to the South China Sea. And they've used the international institutions to good effect, frankly, to lay out their legal claims according to the United Nations Convention on the Law of the Sea in the South China Sea. And we've sort of seen a rather systematic Chinese response based in power and coercion, all the way from, some people refer to it as gray zone, right? In fact, my colleagues and I did work on that. This idea of, using militias, using the Coast Guard, right, to try to pursue their claims at a lower level, but also, using military power. You have the South China Sea bases. Everybody focuses on the three big bases and forget that the Chinese actually have 7 bases in the South China Sea. Well, I mean, in the Spratlys alone, right? Because they have 4 additional smaller bases. They have 3 big ones, each one bigger than the entire Pearl Harbor and Hickam Air Force Base, area in Honolulu. Each one of the 3 bases is bigger than that, but they also have 4 smaller bases that are radar stations and communication stations, and they have harbors as well, where military activities can occur too. So China has a very strong military presence in the South China Sea as well. And perhaps what we're about to observe is yet another chapter in that process, if it's in fact true, that China's response to international law approaches is power, coercion, and pushing the neighbors around using power and coercion, if that's the case. So that concerns me because it's obviously deeply destabilizing. So those would be my comments on that issue. I'll turn it over to you, and then I hope we can talk about the code of conduct.
So what do you want me to talk about the code of conduct?
Oh, well, did you have anything to reflect on what I just said or no?
So I think China keeping the South China Sea, dispute in South China Sea and the tension in South China Sea maybe as a scapegoat for China to deal with domestic problem, like in Hong Kong right now, or in Xinjiang, or other places that China have a domestic issue. I have no further idea.
Yeah, okay. So before we run out of time, we have 10 more minutes. I'm glad to use it. If anyone has questions, please go ahead and add them. But I'd like to talk a little bit about the code of conduct process. I've been writing Carl Thayer, for instance. I don't know if you know Carl Thayer. I imagine you do. Has been writing. He's been keeping us all up to date on this. He writes good stuff. And one of the things he pointed out was even within the code of conduct process, China's draft proposal was an attempt to remove the tools that Southeast Asians have to kind of equalize the power dynamic in the South China Sea. So that would include Southeast Asian states would have to refrain from undertaking joint military exercises without China's permission, right? Essentially, right? And the same thing would be true for hydrocarbon development, right? No hydrocarbon development without Chinese participation. Essentially, is the summary of it. So you noted in your diplomatic options that moving forward with a code of conduct is a possibility. Given this sort of Chinese approach, what are the real possibilities for a code of conduct?
The real possibility of the code of conduct is maybe this is the answer for ASEAN government to answer their citizen inside the country. Look, we're doing something, and we are not abandon the situation. We are actually working and use your tax to work. But I'm really skeptical about the vision that we have the code of conduct with the whole meaningful meaning of it. For example, the code of conduct, like we expect it to be legally binding on the country, or it's just another DOC, Declaration of Conduct, that have no legal basis, no legal binding effect at all. And also, the code of conduct will not limit other party in the process to use other peaceful means except for just negotiation. And it's already too long. It's more than. So I don't have really high hope on that.
Yeah. So what diplomatic processes do you think might be more effective? Have you given some thought to that?
So, for example, Indonesia at the moment is using the UN to the UN as a platform to condemn China violate human rights of Indonesian fishermen in the South China Sea. And maybe the UN is also a good place for other countries to express their condemnation against China. And also ASEAN. ASEAN is the biggest international organization in the area. And ASEAN now have a legal personality, which can use all the legal tools or participate in the negotiation of the conduct as a party as well. That's my other thought.
Thank you. So we have a question to someone who might like more clarification concerning China's approach to archipelagos. We talked about that earlier today, but I think this person would like a little bit more clarification. So I'm glad we have the map up of the South China Sea because you have the parasol islands there with the baselines around the parasols. Maybe you could talk a little bit about why China claims that it has internal waters in the South China Sea and what that might mean in terms of these archipelagos.
So let's take the parasol archipelagos as an example. So this is, so we have offshore maritime features and it may be close to each other, but it doesn't mean it linked to each other legally. So for China, this parasol archipelagos is one, how to say that, is one group that every individual linked to each other. Therefore, they can, therefore that they draw the straight baseline around this parasol to claim internal water within the system of the straight baseline around here. And then toward the sea, they have territorial sea and then EEZ and continental shelf. But these kinds of practice, first, it violates the law of the sea itself because China is not archipelagic state. So you can, this is the practice only for archipelagic state, as the Philippines. And also
and Indonesia, yeah.
Yeah, in Indonesia, and before the ratio of land and water in here is not 9:1, but like 1,000, and it doesn't make sense to have the whole parts of the sea within this area of internal water. And also, this kind of practice is already defined or already put in consideration in the before an international court in the judgment of 2016 between the Philippines and China. The court already, the tribunal already say that the maritime features in Spratley Act you should consider is a individual. You cannot group it together and see it as a group that can generate everything at sea. This actually practice is because of France in the colonization time, that when France want to claim sovereignty in the maritime feature in the South China Sea, they draw this kinds of line and they send it to the UK to ask the UK to recognize the practice of France. And the UK said, no, you cannot do that. You have to name its maritime feature in the Spratley or in the parasol, and then you claim sovereignty, and then you claim the maritime feature around that. It is an island. So maybe before that, France has already have the map that broken that. Maybe it was copied by China. So for modern international law of the sea, this kind of practice is violates international law and also denied by an international court.
Well, that's terrific. You've really given us a lot of great insight. I'm going to ask you for one more insight, which is, how likely do you think it is that that Vietnam will proceed with the arbitration? What do you think about that?
So it will be, if the arbitration against China, this will be the last resort for Vietnam when other options become exhausted. And we have, and as I said, we have the indicator of that. Vietnam now fulfill the obligation to exchange view according to Article 283. And I hope there will be a case.
Yeah, I think that's terrific. We understand you don't speak for the government, but I think everyone should take note of this point that you just made, right? That Part 15 of UNCLOS is the dispute resolution part. And one of the steps required in the process of litigation, it's a step precedent to litigation, before litigation, is to have this as clear exchange of views. And that this is what Vietnam is now in the process of doing, of putting its views clearly in the international record and systematically and fully. so that essentially so that the litigation trigger can be pulled, right? So this is the last step before litigation can occur. So that does tell us quite a lot about what the Vietnamese government is thinking, and I recognize you can't speak for them. So, so thank you. I cannot thank you enough, Min, for a really terrific presentation and discussion today. I regret we didn't get to have Jerry in the conversation, but it's been really terrific. I'm afraid our time has come to an end. So I would like to share, sorry, my button. I would like to share that we do have another Zoom talk coming up. The final talk of the semester, as I mentioned, will be on Wednesday, June 3rd. So we hope that you will join us for that. And I hope you will all join me in virtually thanking Min for a really wonderful talk and presentation. Thank you for a great time. Thank you, Min.
Thank you very much for organizing this event as well. And have a good day in the US.
Yeah, thank you. It's been our pleasure, and you get a good night's sleep.
Thank you very much.
All right. Bye-bye, Min.
Bye.